All rise. Judge Vanderbeek Court is now in session. Judge, this is case number JVB 1034, Thornton case.
Thank you.
You're welcome.
You all may be seated. Mr. Thornton,
Yes, ma'am.
you're back. How are you doing?
Oh, not as well as I'd like to.
Okay, all right. You brought this case before the court. What's going on?
Well, Your Honor, there's been some significant changes in my situation. And as you can see, Ms. Hernandez is not here today. And I have custody of the boy, and I have been, making our arrangement payments to her.
Okay.
But since the boy has come to stay with me, he's gotten himself into a lot of trouble.
Okay. What kind of trouble?
Well, he's been burglarizing some residents, and he was in an accident due to a police chase.
This is AJ, right?
Yes.
Okay.
All right, folks, let's dive into this courtroom drama. The judge calls the session to order as Mr. Thornton steps forward to present his case. He explains that he has custody of his son, AJ, and has been making payments to Ms. Hernandez. But things have taken a serious turn. AJ has been in trouble with the law, including burglary and a police chase accident. The judge listens intently, asking about any changes in living arrangements or expenses. Mr. Thornton's frustration is clear as he describes the financial strain caused by AJ's actions. But this case is about more than just money. It's about responsibility, legal obligations, and the challenges of raising a troubled teen. How will the judge handle it?
And Ms. Hernandez refuses to acknowledge her responsibility to help me in covering some of these costs. I mean, the medical costs are quite extreme. My insurance is refusing to pay because it was a criminal act. In fact, they're probably going to drop me.
Okay.
And
If I remember correctly, you guys agreed to no child support during mediation.
yes, ma'am, we did.
Okay. And since that time, nothing has really changed with the living arrangement. AJ still lives with you,
Yes, ma'am.
and you still have not been paying child support. You've been making the back child support payments.
Yes, ma'am.
Okay. Other than AJ getting in trouble, what else has happened? Like, what has changed?
Well, she has moved out of state, quit her job, so her insurance no longer covers him.
This complex situation? Let's find out. Mr. Thornton lays out his case in detail. He explains that Ms. Hernandez has moved out of state, quit her job, and her insurance no longer covers AJ. Now he's bearing the full financial burden, including medical bills, court fines, and accident-related damages. The judge reminds him that during mediation, they agreed to no child support and asks whether there has been a material and substantial change in circumstances. Mr. Thornton struggles to prove a significant change. After all, AJ has always lived with him. His frustration builds as he realizes the legal obstacles in his path. This moment highlights the emotional and financial stakes. His plea for support is met with the judge's insistence on following the law.
In that aspect, and the court costs, fines, and due to that accident, there was a lot of damage in which he's liable for, or I am, and it's almost impossible.
Okay.
For me to,
But AJ was double insured by both of you, right?
yes.
Okay, here's the issue. In order to modify any type of child support situation, whether you receive child support or you don't receive child support, there has to be what's called a material and substantial change. That means that AJ's living arrangements would have had to have changed. Something about his educational expenses have changed. Something about mom's income would have had to have changed, but in you guys' case, you agreed in mediation to no child support. So to go from no child support to receiving child support, you would have to fall in one of those categories for a material and substantial change. And based on what you said, you really don't fall into one of those.
That's very disappointing. So she's just
Law. Will he convince the court, or is this fight slipping away? The judge takes center stage, outlining the legal standard for modifying child support. She explains that a material and substantial change, such as a shift in living arrangements, educational needs, or income, is required. But in this case, none of those factors have changed since the mediation agreement. Mr. Thornton voices his frustration, feeling that Ms. Hernandez has walked away without responsibility. The judge quickly clarifies that their agreement was mutual, and that the law doesn't allow changes without significant new circumstances. Her no-nonsense approach leaves no room for argument. The ruling is clear, and Mr. Thornton is left disappointed. This is the heart of the drama. The judge's sharp, legal reasoning clashing with Mr. Thornton's emotional plea, making for a tense and compelling courtroom scene. The judge remains firm, carefully explaining her decision. I wouldn't say she's completely free of obligation, she clarifies, but you both agreed in mediation to no child support. To modify that, you must prove a material and substantial change. She offers an example. If AJ had lived with Ms. Hernandez at the time of mediation but now lived with Mr. Thornton, child support could be reconsidered. But since nothing significant has changed, Mr.
Free of any obligation? I mean,
Well, I wouldn't say she's necessarily free, but remember, you all did come to an agreement in mediation to no child support. So in order to start receiving child support, you would have to show that something has changed. So let's say, for instance, at the time of mediation, AJ still resided with her. Now he lives with you, then we can entertain child support at that point. But nothing has really changed since you guys have gone to mediation. Therefore, you wouldn't be entitled to receive any child support, unfortunately.
I understand. I mean, is there nothing I can do? Absolutely.
As far as I'm concerned, no, there's nothing you can do. Yeah.
All right. Thank you,
Okay,
Your
is there
Honor.
anything further?
No, ma'am, not at this time.
Okay,
That's about it.
okay. Well, if there's nothing further, you're dismissed.
Thank you.
You're welcome.
Thornton isn't entitled to support. His frustration is evident as he asks, "Is there really nothing I can do?" The judge's response is final. No, there's nothing you can do. With that, the case is closed. Mr. Thornton, clearly disappointed, thanks the judge. The courtroom falls silent before the judge officially dismisses the session. It's a sobering reminder of the weight of legal agreements, regardless of shifting emotions. The judge reiterates her ruling. Under the current circumstances, Mr. Thornton cannot receive child support. She firmly states that the mediation agreement stands and dismisses the case. Mr. Thornton thanks the judge but leaves the courtroom visibly frustrated, knowing the financial burden remains solely on his shoulders. The judge's final remarks emphasize the importance of legal agreements and the need for substantial changes to modify them. This moment delivers both the resolution and a key takeaway, ensuring viewers understand the strict legal standards in child support cases. A legal breakdown, a lawyer steps in to analyze the case, explaining that under Texas law, modifying child support requires a material and substantial change, something that didn't happen in Mr. Thornton's situation. Because of this, the mediation agreement remained in effect. The video ends with a call to action, encouraging viewers to share their stories and subscribe for more legal insights. This case serves as a powerful reminder of the complexities of child support laws and the importance of seeking legal advice when facing similar challenges.